North Carolina has a landlord-friendly breaking lease framework with a clearly established duty to mitigate and specific provisions that protect both landlords and tenants. The governing law is found in North Carolina General Statutes Chapter 42, which covers landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in North Carolina, the state provides a workable framework that gives landlords broad discretion while requiring reasonable mitigation efforts. Let's start with the landlord's duty to mitigate damages. North Carolina law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty has been established through North Carolina case law and is well recognized by the state's courts. The landlord cannot simply leave the unit vacant and hold the departing tenant liable for the full remaining rent. The landlord must take reasonable steps, advertising the unit, showing it to prospective tenants, and accepting a qualified applicant who meets the landlord's standard screening criteria. If the landlord re-rents, the departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs, advertising, cleaning, make-ready work, and leasing expenses. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. North Carolina's mitigation duty is based on case law rather than a detailed statute, which means the standard of reasonableness is developed through court decisions. Courts evaluate what's reasonable based on the local market, the property's condition, and the landlord's typical marketing practices. Early termination clauses are generally enforceable in North Carolina. The state does not have a specific statute capping early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. The fee must represent a reasonable estimate of anticipated damages. A grossly excessive fee could be challenged as an unenforceable penalty under general contract principles. North Carolina does have a specific provision regarding liquidated damages in residential leases. Under Section 42-46, the landlord may include a reasonable liquidated damages provision in the lease, but the provision cannot waive the landlord's obligation to mitigate. This means a lease cannot say that the tenant owes the full remaining rent as liquidated damages with no mitigation required. The mitigation duty exists regardless of what the lease says. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. North Carolina has an enormous military population. Fort Liberty, formerly Fort Bragg, is one of the largest military installations in the world and generates massive rental demand in the Fayetteville area. Camp Lejeune near Jacksonville, Marine Corps Air Station Cherry Point near Havelock, and Seymour Johnson Air Force Base near Goldsboro all generate significant military rental demand. SCRA lease terminations are an everyday occurrence across North Carolina's military communities. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Landlords near any North Carolina military installation should have SCRA processing as a core business competency. North Carolina has enacted protections for victims of domestic violence and sexual assault that allow early lease termination. Under North Carolina General Statutes, Section 4245.1, a tenant who is a victim of domestic violence or sexual assault can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid domestic violence protective order or a copy of a criminal complaint for a sexual assault that occurred on the premises. The tenant must provide at least 30 days written notice. When a domestic violence victim terminates, the tenant is responsible for rent through the termination date, plus any amounts owed for damages to the property, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. Tenants in North Carolina may break a lease if the landlord fails to maintain habitable conditions. Under Section 42-42, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, and maintain essential systems. If the landlord fails to act after receiving written notice, the tenant has remedies that can include lease termination. From a practical standpoint, North Carolina has one of the fastest-growing rental markets in the Southeast. Charlotte, the state's largest city, has an extraordinarily competitive market driven by financial services, healthcare, and corporate relocations. When a tenant breaks a lease in Charlotte, the landlord can typically re-rent within 2 to 4 weeks in desirable areas. The Research Triangle, Raleigh, Durham, Chapel Hill, has similarly strong demand driven by technology, biotech, and universities. Greensboro, Winston-Salem, and Asheville have moderate to strong markets. The military communities, particularly Fayetteville near Fort Liberty and Jacksonville near Camp Lejeune, experience constant SCRA-driven turnover. Landlords in these communities should treat military lease breaks as a normal part of operations. One best practice for North Carolina landlords include a clear early termination clause that works alongside the mitigation duty. North Carolina's Section 42 to 46 specifically states that liquidated damages provisions cannot waive the mitigation obligation, so structure your clause to provide a defined fee that accounts for realistic re-rental costs and expected vacancy, not the full remaining rent. Another best practice: document your mitigation efforts meticulously. Keep records of listing dates, advertising channels, inquiries, showings, and when you accepted a replacement tenant. This documentation establishes the departing tenant's actual liability. North Carolina requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit is limited to the equivalent of 2 months' rent for terms longer than month to month, and 1.5 months' rent for month-to-month tenancies. The deposit must be held in a trust account or secured by a bond. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to North Carolina breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.